Good afternoon, everyone. Thank you for attending today's webinar presented by Winvale and Blank Rome on the top 10 compliance risks for GSA Schedule contractors. The last 12 months have created new compliance challenges for GSA Schedule contractors, and today's speakers are here to share with you information and tools on how to best protect your company from these compliance risks. Brian Dunn is a founding partner at Winvale and has 15 years of experience advising clients on new schedule offers, contract modifications, OIG audits, and sales strategy. Mr. Dunn also leads Winvale's audit and compliance services and has supported over 15 GSA Inspector General and Department of Justice contract investigations. Our second speaker is Al Kreichman. Al is a senior partner with Blank Rome and has 33 years of experience advising companies doing business with federal and state governments on all aspects of government contracting and grants. Mr. Kreichman counsels on issues arising at every stage of the government contract from proposal to closeout. In addition to GSA compliance, his practice covers internal investigations, bid protests, contract claims, ethics investigations, whistleblower problems, small business compliance, fraud, and False Claims Act litigation. During the presentation, please feel free to submit your questions via the Q&A tab on the top of your screen. We'll reserve the last portion of the webinar to answer all of your questions. And with that, I will turn it over to Brian Dunn for our first segment.
Thank you, Heather. And a belated Happy Father's Day to all the dads out there. I'm Brian Dunn, and I've had the pleasure of working with Al on a number of audit engagements. And Al and I both can tell you firsthand there are a great number of benefits to an internal audit when you're in control of the project scope, the timeline, and level of disclosures, and you don't have to worry about the stress working against the government auditor. So today we're going to review the top 10 compliance areas that we see GSA Schedule contractors really struggle with and offer some recommendations for each. And since we want to take questions at the end, Al and I are going to try to hit the high points and try to get through the presentation within the 45 minutes we've got. Here's a quote from a former Deputy Attorney General, and I think it summarizes compliance fairly well. You know, contract compliance is a subject that you're not really reminded of until it's too late, when the government shows up at your door to box up your records. But it's an issue that more government contractors need to take seriously and need proactive on. Too many times compliance issues are simply swept under the rug when an employee leaves, and they end up having some significant consequences in the future. Some of you may have seen the latest Department of Justice press release, the lawsuit filed against CA Technologies that came out just 2 weeks ago. You know, the schedule program has $38 billion running through it last year. I think right now we're around 20,000 contractors. So contractors certainly aren't immune to some of the legal pitfalls and compliance challenges. And this one in particular deals with the price reduction clause, CSP charts that many are familiar with, that continues to present challenges for basically everyone. So first we'll talk about pricing compliance. And all GSA contractors should know GSA's price reduction clause. It's the backbone for the schedules program and is probably the cause of many sleepless nights, many interpretations of the clause. So what GSA does is they establish a price against a contractor's basis of award customer, and that pricing relationship and that customer must be maintained throughout the contract term. So should there be any change to the basis of award customer's price, GSA, they're entitled to the same discount so as to maintain the original pricing relationship. You know, the first problem that Al and I see from GSA contractors is really there's no sufficient training and communication to the company. And training is by far the easiest and most cost-effective measure that gets the greatest results. And if you think about it, the price reduction clause has nothing to do with your federal transactions. It has everything to do with your commercial market or your basis of award customer. So we work with our clients on employee training, on updating sales policies. You know, I've seen that the first thing government auditors will ask for is written documentation. So within your sales policies, and as you educate, you know, contractors need to establish and maintain a pricing floor, which is simply the lowest price you can offer to your basis of award customer. You know, make it simple. The second issue we see, our GSA Schedule contractors don't have a system in place to monitor the basis of award discounts. If they do, it's a very manual process. Many don't know who their basis of award customer is. And even if they do, you know, how do you know you're not at risk for a pricing violation? And once you have access to commercial sales and that data, you know, do you know what causes a price reduction? And if you find a price reduction, are you disclosing it to the contracting officer within the 15-day deadline? Lastly, don't just look at transaction prices when you're reviewing basis of award customer transactions. You know, remember to review concessions. Concessions is usually the first thing that's overlooked. You know, concessions could be defined as freight allowance, extended warranty, extended price guarantees, free installation. You know, there's a lot of things that fall into that bucket that can also disturb the pricing relationship. Next, we'll talk about GSA pricing. You know, how you sell your GSA contract to eligible GSA Schedule buyers. As we all know, the Schedule program is a federal program. It's a federal contract. So Congress restricts who you can sell to. And you also need to know what customers are authorized to buy from the Schedule contract. And we all know GSA can be very sensitive to contract scope, you know, where contractors can only sell products and services that are approved on their GSA price list. Again, a reoccurring problem here are our employees don't know who can buy from the GSA contract. An easy fix is to download the GSA eligible entities PDF from GSA's website, and we've provided the link. You can also get there through a Google search. And this is usually updated every year. And you'll be surprised to see some of the authorized buyers on this list. It's certainly not just limited to the executive branch of the federal government. Another problem we see are employees don't know when to put their GSA contract number on a quote, or how to handle it when a buyer wants GSA approved items and non-GSA approved items. So if the quote or the proposal was done wrong in the early stage, then obviously the award will probably be wrong, and it probably won't be invoiced correctly, and then reported in your quarterly 72A sales report. So, you know, what we recommend is, you know, for our clients to establish a GSA pricing desk or a central resource where everybody can go and get the pricing correct from the beginning. And somebody can monitor compliance and can answer questions for other employees who aren't quite sure. Lastly, audit your recent quotes. Be proactive. Look at the invoices you've sent out, your quarterly GSA sales reports. You know, we know the GSA auditors that come out, they use fpds.gov, which is the Federal Procurement Data System. It's just one of the main databases that the government will report into, and it will show how your federal buyers are reporting the purchase, the contract action against your contract. So you can just go there, you can plug in your DUNS number, and you can compare and contrast against your records for what the government has.
This is Al. I would just like to comment on Brian's presentation on this aspect of it, which is that companies need to continually assess whether they have the capability to have this compliance infrastructure. Remember that we're talking about firms that have their own GSA schedule contract. You've looked at the solicitation, you've made a proposal, you've negotiated a contract, and you've won award. You have to ask yourself, am I able to perform? And if the answer is yes, and you can follow those compliance tips that Brian went through, then go forward with the schedule. But if not, there's an entire reseller structure that exists where manufacturers and others can elect to go through a GSA reseller, and those resellers pick up many of the compliance elements that are covered because they are the ones that hold the schedule. So understand that this applies to the schedule holders, but that if you believe that you may not be able to do this in compliance, there is an alternative in the reseller market.
Yeah, good point. So terms and conditions are another important compliance area. Most of the time, there will be a few GSA terms that are going to be different from your commercial business. But just as an example, we have minimum order. There are payment terms and volume, tier pricing, delivery terms, warranty terms, service terms. All of them are unique and should be aware of. So the common issues here we see are the terms and conditions are sometimes not correctly communicated internally or to the buyers. Most of the time, as employees just don't understand that there are differences between the two. If you look at one of the examples we put here on freight and delivery, your commercial term might be that the customer pays for shipping. You'll ship it anywhere. It'll take 30 days. But opposite of that, a GSA schedule customer, they may get free shipping within just the continental United States. And it has to be there within 2 weeks, and it has to have a material safety data sheet with it. So there are definite differences sometimes with delivery terms, among others. We also see issues with prompt payment. For some contractors who have negotiated a prompt payment term on their schedule, I'll tell you that the Inspector General recently finished an analysis where they found where GSA contractors, when they show the agreed upon prompt payment term on the invoice as required, such as 1%, 15 days, net 30, that the government takes advantage of that 1% savings about 60% of the time. So what they're doing is they're now auditing contractor invoices, and if you fail to show it, they're demanding refunds attributing to that 60%. So the solution with these problems can be solved with simple employee training, being proactive in your audits internally, and make sure that nothing is missed. With that, I'll turn it over to Al, who will talk about small business contracting.
Thanks, Brian. As many of you have probably seen, recent news reports and announcements by the Department of Justice that reflect an increasing focus on small business compliance. And this is something that can apply to a GSA schedule. There can be a set-asides specified within schedules, and of course it applies to freestanding acquisitions that are set aside for small business. And what we have seen and what we wanted to communicate is that again, there needs to be increased attention in the area of small business compliance because, as some of you may be aware, back in September 2010, President Obama signed the Small Business Jobs Act, which included a provision called the presumed loss rule. And this rule essentially can cause a small business or team of a small and large business to forfeit the entire amount of their contract if it turns out that their certification was intentionally false. So what do we see here as to the particular issues that create most problems? The easy ones that I think most companies have their hands around are, do I have the right number of employees, or have I calculated my revenue properly? I mean, those are well-known issues, and again, I think most companies are able to do that. Although we still see occasionally problems where part-time employees are not counted, or companies miscalculate the 3-year average annual revenue. The real landmine here is the affiliation, and that is kind of the third leg in the stool, where in addition to being sure that your company is under the employee limit, if it's an employee limit size standard, or the revenue limit, you have to watch out that some transaction or agreement or corporate ownership relationship has not triggered an affiliation between two small businesses, or else that small business is deemed to be affiliated as a matter of law, and then the employees and the revenues are combined. So we're suggesting, and we help with this, that for firms proactively check for possible affiliation, because it could also lead to a bid protest, it could lead to a whistleblower case, any number of negative things can occur. Also, a number of contractors have not been updated on the new limitation on subcontracting rules. Those apply to set-asides in which the prime contractor and the subcontractor are restricted into the amount of subcontract dollars that can be paid to or provided to a large business subcontractor. It used to be that you looked at, under the old rule, the cost of labor performed by the prime divided by the total labor costs. The 2013 NDAA changed that, so now you're looking at the amount paid to the prime or similarly situated entity divided by the amount paid under the contract. This is a pretty significant change, and firms need to be aware of it. You need to look at your solicitations to see if they've updated the clause, and get clarification if the old form is used, because the statute was effective immediately. And now let me. So I think with respect to small business, we've just suggested that companies proactively look at these issues and do an audit check. I want to now shift to another area that has created issues, which is the Trade Agreements Act. There's been much press also in this area. We were just at a meeting with the Department of Justice Fraud Division last month, talking about this, and the lawyers' eyes rolled with a number of cases that have come in under GSA Schedule contracts with companies that are not complying with the Trade Agreements Act with respect to the country of origin. This is a cottage industry for whistleblower complaints. It can look like low-hanging fruit. When does it happen? It happens when essentially you're selling a product that's manufactured in a non-designated country. It may contain a express representation to that effect, or it may have an unclear COO on it. So what are the common issues in the Trade Agreements Act that trip companies up? Well, some of you know that the GSA furnishes its own letter of supply format, and that letter, indicates, a representation as to the country of origin. But the truth is that many manufacturers try to wolf one by the reseller or the distributor by putting unclear terms in their documents, such as partially assembled in Mexico. I mean, you see something like that, it's a red flag. You might believe that you are in compliance, but the words are such that, in fact, it should be a signal to the opposite, that, in fact, it probably has a problem. So we're recommending that you refresh your letters of supply, check the designations. Don't put yourself in a position where you may have to write a 6- or 7-figure check back to the government for selling products that violate the Trade Agreements Act. We suggest that you do spot checks, look at what you're getting in, look at the markings, and be sure that if you see something ambiguous, you act to try to clarify it, and if you can't get clarification, step back and probably remove it from your schedule, because that would be the safest course. So what we've talked about in the last two segments really are Trade Agreements Act and Small Business Act compliance. They are elements of your government contract. But another element of the government contract that also overlays these two and many other obligations is your code of ethics. It's important for a firm that does business with the government to have a code of ethics and compliance plan that is tuned to government contracts. The standard one that you get off the internet, which just has honesty and no gifts and employee integrity and et cetera, is not effective and is not tuned to government contracts. And when a GSA or DCIS, Defense Criminal Investigation Services, or OIG auditor comes in and asks for a copy of your corporate compliance plan and ethics program, they will look to see whether it deals with the specific issues in government contracts, because that's what they're looking for. They're looking for things that talk about procurement integrity. They're looking for things that talk about the Anti-Kickback Act. They're looking for things that talk about the revolving doors issue. They're looking for your zero tolerance gift policies and Buy American Act and Trade Agreements Act compliance. All those things are elements that you would see in a government contract tuned plan, but wouldn't exist in a commercial plan. And we have assisted numerous clients with updating their plans to be sure that they pass muster. And as we go into the common issues, I've mentioned most of them. Do not accept that your generic codes are sufficient. Update your codes to make sure, and I'm going to talk about this at the end, something called the mandatory disclosure rule. We've been in situations where the first thing that an OIG auditor comes in and says, let me see your plan, and let me see the signed certificates of training that your management has been trained in these issues. And the proper answer is not what certificates. You have to have these records in place, conduct the training, and ensure that, because this is a famous ounce of prevention issue. If you have that, you have taken a great step toward ensuring that, or helping the perception of the auditor that they can have confidence in your systems and procedures. And so when something goes wrong, you can portray it as a one-off. So having covered these basic core issues in your ethics and business plan, I want to now turn it back over to Brian for some specific pitfalls related to human resource requirements.
Thank you. The last thing I'll add to that is, we're seeing a lot of prime contractors flow down this ethics issue and ask other contractors for a copy of it. So, this isn't something that is considered a deliverable that has to be signed off on, but, having it in place, showing that you've got a level of confidence to your prime contractors, and then also, depending on the dollar threshold, you also have to flow down this requirement to your subcontractors. So this is just going to be an issue that's very bipartisan. It's just going to get to be a larger, more pronounced in government contracting. Human resources, another department within your company that should be aware of federal contracting compliance. It seems that Congress and executive orders from the President are constantly coming out with new requirements for contractors. Employment laws are changing. In fact, President Obama, I believe today, is supposed to sign an executive order protecting gay employees who work for federal contractors from discrimination. So this is a way within his authority, he can circumvent Congress and pass this down to our community. So here are a few HR requirements to be aware of. Some of these have reporting requirements underneath them. Some deal with things like minimum compensation. One of the first problems we see in this area are contractors just don't know the requirements and when they're applicable. Some like EEO-1 and affirmative action are only required when a federal contractor has 50 employees and $50,000 in federal contracts. So, when we speak with an HR manager, the first thing I'll tell them is, go to the Department of Labor's OFCCP website, read some of the information they've got there. Their mission is to ensure federal contractors are compliant with the employment laws. And they will also be the one that conducts the majority of desk audits. And for those who have gone through a desk audit from OFCCP, there's a lot of, it can be quite painful. The next issue we see here with service contractors are, those that have defined GSA labor categories. If the government is paying for a labor category with, let's call it a program manager, if they've got 10 years experience and a master's degree, you have to make sure the person that's filling that work has those minimum qualifications. And this requirement doesn't just stop with you or go away if you use a subcontractor, or if they have a subcontractor, which is a second tier subcontractor. So I've seen the Inspector General's office, this is one of those trends, they're really looking for this information as a way to make sure that the government is getting what they pay for.
One of the ways that the government makes sure that it gets what it pays for is is to look at the small business subcontracting plan of prime contractors who are large businesses to ensure that there has been compliance. When you enter into a government contract, you're entering into more than just a simple financial transaction. You're entering into a social policy instrument where you are agreeing to fulfill social policies that it may drive your costs up, but nonetheless are deemed important by the federal government for policy purposes. And the small business subcontracting plan is a prime example of this. There are clauses in your contract that have different dollar thresholds that will require different actions. At $150,000 prime contract level, I call it the utilization clause, which is just essentially a commitment to utilize to the best extent you can small businesses. That's somewhat of a toothless commitment. It just says do what you can, and that is in contrast to the actual formal small business subcontracting plan, which kicks in over $650,000 for large businesses. If you have one of these small business subcontracting plans, that should have been negotiated at the inception of the contract, often at GSA through an SBA representative who's sitting at GSA, and they will negotiate your various percentage goal categories across the form. You will then have to appoint someone as an administrator, and that person will own and be accountable for performance under the small business subcontracting plan. Now, for many years, this was just viewed as a document that went in a drawer, never looked at. It was not a critical. But now, under this administration, there's increased focus on it. In fact, we were involved in a matter recently where Defense Contract Management Agency held up our client's option year until it had renegotiated the small business subcontracting plan goals. So, so this can be a showstopper, and as indicated in in the slides, they have now increased the strength behind it through the 2013 National Defense Authorization Act, provided that failure to follow and failure to make the good faith effort to reach your goals can be a material breach of the contract. It can trigger the assessment of liquidated damages, and it can be noted as an adverse past performance element in your rating, which essentially means that you could be done in government contracts. If you have one of these negatives in your file, if you're in a close competition and the issue is past performance or the issue is compliance, you're going to be at a significant disadvantage in the evaluation factors against your competitor. So this needs to be taken seriously. It would be a self-inflicted wound to have undermined your company's competitiveness because no one has pulled the subcontracting plan and taken a look at where you are against the plan. And believe me, sometimes companies are surprised when they pull this out. They go compare their data and realize that they have to significantly alter their supply chain. We've had that situation, and sometimes it has to happen in a hurry. So the benefit of checking this and looking and being sure that you're in compliance early before it's caught, is tremendous. Agencies also under this new law have to collect performance data, and also one change that actually may reduce the burden on some primes is in the 2014 National Defense Authorization Act. This is something that's been asked for by industry for many years, and that is to allow prime contractors to count lower tier subs below the first level. This is a way. The SBA has to do a rule on it. I have a feeling that it's going to go to the absolute bottom of the pile at the SBA, since arguably it may cut against increasing subcontractor performance. So I wouldn't look for it anytime soon, but be aware that it's out there. With respect to some common problems that we have seen and remediated, other than those I outlined, you're often obligated to get information about whether these companies are in fact small or compliant with the various categories. You may have 8A, you may have hub zone, you may have small disadvantaged, woman-owned, service-disabled, veteran-owned. You must get certifications from these contractors of their status. Now, some can be verified through databases, but certainly small disadvantaged businesses, some woman-owned businesses don't need official SBA certification, so you have to depend upon them. We have helped firms design surveys that you can capture this data, because you must have correct data of the profiling your supply chain to know where you are against your goals. Another problem is that there are inaccurate reports and some misunderstandings on some of the SBA forms and filings. If you're not sure, if you don't understand what it means to say whether indirect costs are included or not, we certainly can help you with that. But it is very important to be sure that you understand what you're certifying to. And this review of the subcontracting plan may happen in connection with the GSA contractor assistance visit, which Brian is going to talk about next.
Thank you. And the last bullet here, the new GSA IOA report card just came out last month. It's just being filtered down to the IOAs. When we first saw it, we noticed the number of questions jumped from 23 to 48. And they've added 13 questions that just deal with your subcontracting plan and the performance and meeting your goals. This was rarely breached during an IOA visit before. Now you can tell that they're taking a much more serious approach to this thing that's been long ignored. So, if you haven't done it yet, look for an outside expert or a third party to help sort of validate your approach. Al mentioned that the SBA is very specific on how this survey needs to be read and how it needs to be received and pulled into the data. So be prepared. These IOAs may be a little bit green that first visit out, but they'll pick this up soon later. So regarding the contractor assistance visit, we always say they should change assistance to assessment, but this is an audit that I'm sure everybody on the phone is somewhat familiar with. The IOA comes out 2 times every 5 years. Sometimes it's 3 times. They may not bring luggage and a few of their colleagues like the IG office will, but remember that everything that they're going to see and hear, they are going to turn it over to your contracting officer, who has the ability to turn it over to somebody else, like the IG or the Justice Department. We're also seeing these assistance visits. Some of them are being remote right now. They're kind of paring down the 2 different types of contracts. Ones that are high profile, that generate dollars, and some that are generating very little, that they may just do something via a phone call or a webinar or something like that. But you can see some of the bullet points that they do address within their visit, which can go from 4 hours to 8 hours. Sales reporting, pricing compliance, TAA, some of these issues we've talked about already, and the accuracy of the contract terms. So the first problem we see here, GSA Schedule contractors, they do not take this meeting seriously, or they rush and prepare at the last minute. So please spend time, get organized, rally the troops. Oftentimes say that if you look organized, then if you printed your GSA binders, you have your staff available, you're halfway to a successful visit. We also see that the IOA will come in with notes from the last time. And the first thing that they'll ask you is, did you fix what we addressed last time, which might be 2 years ago? And I've seen consequently GSA, they're subscribing to this 2 rules, 2 strikes and you're out type mentality, where if they're coming in, they've identified an issue previously, like for example, you're not monitoring the basis of award, customer transactions. If the IOA asks you the next time, how are you on this issue, if you still haven't addressed it, I've seen the CO reach out to you almost immediately and either want a corrective action plan in place, or they're going to cancel the contract. So, and believe me, GSA right now, they are looking for opportunities to further reduce the number of contractors on the program and their administration of it. So treat these IOA visits seriously. And the last problem we'll mention today here is that, because some of these IOA visits are remote, some of them, these IOAs are getting into different subject areas. They are asking contractors for access to your records, to your data. We're seeing a lot of them say, send me your sales transactions for the previous 12 months in Excel and follow the following column headers. And although they have the right to this data, it does make me nervous. If you're submitting to them confidential, proprietary information, you've got to make sure you mark it as not being made public. Mark it as confidential. That way, whatever you submit to the government is stamped accordingly, and it can't be made public.
The last topic that I'd like to cover with you is something I alluded to before, and it's called the mandatory disclosure rule. This has actually been on the books since 2008, but it's one of the provisions that are on the list of some of the first things that an auditor will look at to see in your plan whether or not it has been, as I said, tuned to government contracts. This this provision essentially requires self-disclosure of credible evidence of certain types of misconduct that are listed in the regulation. We reprinted some of them in the slides. This requirement works its way into the FAR in two different places. It exists in the cause for suspension and debarment section, which applies across the government and across all size contractors. And then there are specific contract clauses that have dollar thresholds that it specifically incorporated into. But because it's been made essentially contract-wide through incorporation in the suspension and debarment provision, it's critical for every contractor, large and small, to be aware of it, to include it in their plan, and to have a system in place that is essentially an anti-fraud process, where there would be a way for employees to report apparent problems, a manner of investigation, a particular official in the company, a general counsel or a vice president or some senior official who is charged with looking at it, acting upon it, and then decisions have to be made if one of these issues are identified about whether or not to make a voluntary disclosure. So what are some of the problems that we have seen arise with the mandatory disclosure rule? Well, first of all, we see that some contractors don't have systems to recognize this. They haven't trained individuals. There's no one responsible for it. They don't understand it, and therefore they don't even have a way to identify the problem and a reporting system up the management chain to deal with it. We had a client several years ago that they got a call from the government indicating that they had learned that an employee who was assigned to evaluate competitive proposals had started giving out competitors' proposals to each competitor. Obviously, a violation of the Procurement Integrity Act. Proposals are supposed to be confidential, and you had this employee who was essentially handing them out to try to create an auction, thinking that he was going to be a hero because he produced a reduced price. Well, in fact, he lost his job and faced criminal indictment for violating this, and the company found itself in a ditch because it didn't have a system and it didn't catch it itself. The management of the company had gotten word of this and did not act on it in a timely fashion, and so they were put through a show cause proceeding about why they should not be suspended or debarred. So understand that the mandatory disclosure rule is a significant obligation. I would just commend you, pull out your ethics and compliance guides after we're done this webinar, and look to see where the mandatory disclosure rule is in your materials. If it's not there, that means that your materials haven't been updated since 2008. They don't comply, and you need to. We recommend strongly that you update it to be sure that you're covered. Our recommendations, to deal with this are to conduct an internal audit. Certainly check to see what your documents look like, whether you have a plan in place. Identify if there are any reports of problems. We see, in some cases, we will do an analysis of a particular fact situation after an investigation, and the client will then need to make a business decision on whether or not it will make a voluntary disclosure. Brian and I just sort of finished a matter in which involved a merger and acquisition where the acquisition target did have to make a voluntary disclosure of GSA pricing violations as a condition of the transaction, and this was caught in a due diligence that was done internally prior to the acquisition. And as a result of that work, it saved the client possibly from writing a 7-figure check, and instead all these actions were remediated and resolved favorably fairly quickly. So those would be a important strategy. It's an important decision to make. And I'll also add that sometimes companies decide not to make the disclosure. You may do the investigation, you may look at the circumstances and facts, and you may just make the election. I'm going to take the risk. I'm going to hope nothing happens. Many firms have done that, and and that's sort of a roll of the roulette wheel. But it is an option, and it needs to be carefully considered. And with respect to sort of the big picture, we've talked today about lots of issues, 10 compliance risks. We've talked about strategies to deal with them, and we've also given thought to, okay, what would be a solution to this? What would be a effective and cost-effective and expedited way for you to get a handle on whether you have any of these issues? And I want to turn this over to Brian because I think he's got some thoughts to share with you on that.
Thanks, Al. Today we hit some high points on 10 issues. Those are certainly not the limit to what we kind of tackle here. They are probably the brunt of them, but there are a ton more. And so, as we have alluded to today, how you conduct these internal audits are very critical. So we've had many clients ask for our assistance in a wide variety of ways. One way is that we can do an internal contract audit for you or with you. That engagement could be fixed price. It can start at $3,000 depending on the scope. Depending on what kind of work you'd like to have, we can hit the high points. We can brief management on potential areas of non-compliance. We can offer quick fix solutions as we go or as we identify. And again, we can hit all the areas today or the ones that you feel like that need the attention.
And last, because the question comes in, well, what is the return on investment? Well, the return on investment on something like this, I've alluded to a couple of cases. It can be very, very significant, very high return on investment. If you catch these problems early and remediate them before the government finds them, you may avoid having to write a 5-, 6-, or 7-figure check. It also helps to reduce potential whistleblower cases. You have a complaint, you identify it, you identify an issue, you remediate it. There may not be a case. You'll also, dramatically reduce your audit compliance, and you won't be in a rush to deal with an issue, as Brian alluded to, while the auditor's sitting in the room or while the yellow tape is being spread across your windows and doors and they start carting boxes out. We think that there is a terrific return on investment on this sort of snapshot program. If there has been a serious violation and you're looking at suspension or debarment, the fact that you have taken this action proactively, you have identified the issue, is a huge buffer, and will give you significant credit and as well as good arguments to avoid suspension and debarment. So with that, we've covered a lot of material. I hope you found it valuable. We have received a number of questions, and I'd like just to turn it over to Heather for just a review of some of those.
Thank you both so much for that enlightening and informing presentation. Certainly a lot to be covered in just 1 hour, and we want to get to as many questions here as possible. I do want everyone of the attendees to know that the copy of the presentation, the slides, as well as a recording of today's presentation will be emailed to you after the webinar is concluded. We've gotten a lot of requests for the slides and getting some positive feedback, so just want to make sure everyone is aware you will get a copy of the presentation if you want to pass that along to any colleagues or anyone else that wasn't able to attend, or you just want to be able to review the information on your own time. So if you haven't submitted your question yet, please go ahead and type it into the questions panel, which is on your GoToWebinar menu screen. And as I said, we're going to answer as many questions today as our time permits. Any questions that we cannot respond to here, we will directly follow up with you after the webinar. So our first question is in regards to the IOA report card. And we're being asked, can you send us a copy of this new IOA report card?
Yes, we'll make that available to everybody along with the presentation.
Great. Our next question is the size standard applied against the reseller, GSA contract holder, or the manufacturer?
Well, that's a little bit complicated. Certainly the contractor is the one of record, and there's the issue of affiliation, the way Al mentioned. If it's a small business set-aside contract, that's where it's important to get your representations accurate. If it's not, if it's unrestricted, you're not on as much of an issue. There are some contractors under small business contracts who fail to understand the non-manufacturer rule. So that might be a representation of your employees or revenue along with the manufacturer of the products that you're supplying. It also includes where those products are made. This is the government's way under small business set-aside contracts to ensure you're not supplying products from a large business. So that can get into the non-manufacturer rule, but certainly it's your size standard that counts, not any manufacturers that you're using.
Great. Our next question comes from William, and he's asking, can you please repeat the specific FAR clauses regarding the small business set-asides and subcontracting limits to large businesses that were discussed?
The FAR clause is 52.219.14, which is called limitation on subcontracting. There are different versions of that clause. Now, the important thing to note is that if you open up, the FAR, you may see a version from 2012, 2013. That version has not been, the latest version, to my knowledge, has not been updated to track the change in the subcontracting required by the Defense Authorization Act. We had this problem in connection with a recent proposal where the government put in the old version. We asked a Q&A about whether or not the new law was going to be applied, and they responded in the Q&A that yes, you put in the current formulation of the subcontracting limitation. So you need to look at 52.219.14, and also if you see an old version in there, get clarification from the contracting officer on a proposal as to whether or not the new NDAA formulation will apply or not.
Wonderful, thank you. Our next question in regards to the discounting, and they're asking, if you give a discount from your GSA schedule rate to another government entity, would the rate be considered most favorable, and must it be reported to the GSA?
That's a good question. That is a very common misunderstanding of the price reduction clause. It was a rule that existed back in the 90s, but was updated, where if you offer a scheduled price to an authorized GSA buyer, to a federal entity, lower than your GSA pricing, that does not trigger the price reduction clause. So the GSA obviously updated it because the old rule killed competition. So you can essentially, at any time, for any reason, and any amount, go lower than your GSA price list to any eligible GSA buyer. Obviously, that rule is completely different on the commercial side, but you're certainly okay. It does not have to be made disclosed to the CO.
Okay, great. Our next question comes from Heidi. She is asking, how long should it take to get back the CAV report, the report?
The IOA or CAV report card, that's another good point. This isn't submitted to you by default. You do have to ask for it. We see the IOAs complete this report card typically within a week. They send it to the CO. At the same time, if you ask for it, they can send it to you. So, we usually see it's within 1 to 2 weeks you'll get a copy of it. And it's a great way of understanding how you did. It certainly isn't the end-all, be-all for your compliance because much can be done in a 4-hour meeting. But those positive report cards can certainly help out.
Okay. Our next question comes from Robert. He's asking about the fact that their company passed an audit, but they are being asked to delay their pricing increases. Why do we have to wait 1 year for this?
I'll take that. Price increases, which are also known as economic price adjustments, certain schedules have a solicitation requirement where upon the contract award, the extension, or a previous EPA, you have to hold the prices fixed for 12 months. You're eligible upon an anniversary date. That really varies by schedule and by solicitation. If there are some economic reasons where you're being passed, somebody's passing on to you price increases due to the economy, due to the rising gas, oil prices. There are ways of circumventing this a little bit, provided you've got some documentation. But it's not uncommon for GSA to cap you the number of times and how much you increase prices every year.
Yeah, you can always ask for relief from any of these restrictions. Just don't try them yourself without getting CO concurrence. But if you, as Brian said, if you make an appropriate request, you may and have a justification, you may in fact be granted the relief, despite the fact that the terms and conditions may limit the price increase. And of course, you're not surprised to know that the converse is that you can decrease your price at any time. So they're happy to entertain decreases at any time, but they will restrict increases to the anniversary date unless you have good cause.
Okay, great. Our next question comes from Maureen. She came into the webinar a little bit late and is asking, did you discuss the Service Contract Act provisions?
Well, we've noted that the Service Contract Act is one, just one of the mandatory compliance elements. Certainly, there can be a variety of issues that can arise under the Service Contract Act. Brian did talk about labor rates and the importance of conforming your actual profile to what you have said in the contract. But with respect to the Service Contract Act, we'd also note that there's been problems with contractors getting wage determinations. There have been problems with identifying the appropriate labor classifications when there's unclarity. One of the most important things to understand with the Service Contract Act is it your contracting officer ultimately does not have the final say on many issues. It's up to the Department of Labor, and often that will create an issue. But if you have specific questions under the Service Contract Act related to the coverage of a wage determination, exempt employees, what the prevailing wage means, whether you're entitled to a wage rate increase under the escalation clause, we're happy to help with any of those issues if you could just send us a follow-up.
All right, great. And I'm just going to ask one last question for today so we can be respectful of everyone's time here. And it is, how often do you recommend we review pricing practices for the basis of award customers?
Well, with new technology and new plugins to quoting software or accounting software, there's no reason why this can't be done live or on a weekly summary type report. Hopefully, the people listening, the basis of award for you isn't all commercial customers. If that's the case, I would encourage you to try to restrict or limit your exposure under the price reduction clause and narrow it to a specific customer or a specific class of customer. Certainly all commercial customers is kind of the worst case scenario for somebody to administer, but transactions to that customer base, weekly, monthly, certainly you want to get transparency into what's being quoted. So it's not just the transaction that comes through, but how salespeople are out there with proposals and quotes. You don't want to be seeing things after the fact. If too much time transpires between you finding something out and making a disclosure to the government, it increases your exposure to having to refund the government. That's where your liability falls. It's not just the discounts you've offered to basis of award customers, but in that period, did you have transactions to GSA customers? And if you did, you may have overcharged them because months ago they should have got a better price because you discounted to that BOA. So, not to get into too much detail there, you want to do it as active as possible. That way, you're not looking at a giant bill after the fact and some embarrassment when you're disclosing to the CO what happened.
Great. Thank you all so much for your participation today. This does conclude our webinar for the top 10 compliance risks for GSA Schedule contractors. We appreciate your participation and your active questions. There were many questions we weren't able to get to, so just know we will be following up with you individually through either email or giving you a call to make sure we do address all of your questions. And you will be receiving a copy of this presentation as well if you missed part of any of it. Please don't hesitate to contact us, Brian or Al, or anyone at Winvale or Blank Rome if you do have additional questions or comments. Thank you and have a wonderful day.